Hello everyone, this is Legalized Mimi. If this is your first time here, please subscribe to this YouTube channel, like and comment on this post. Also, share the link to your friends. We're here to talk about the law and reasons you need a lawyer. You can also follow me on Instagram at legalized_Mimi. Okay, let's move on. We'll be talking about an enforceable contract today. However, before we proceed to understand the meaning of an enforceable contract, we have to understand what a contract means. Okay, a contract is a binding agreement between two or more persons or parties. It can also be an agreement between two parties. It creates an obligation to perform or not to perform a particular duty. A contract may be express or implied. An express contract is one whose terms and conditions are defined, whether in writing or verbally. That means it could be in writing or it could be oral. An implied contract, on the other hand, does not include the presence of defined terms and conditions, but these are implied by the actions of the individual. So the court will construe the existence of a contract through the actions of the individual or through the trade practice or customs thereon. So this is the meaning of a contract. Then, what is an enforceable contract? What contract would the court enforce? An enforceable contract is a contract that can be implemented by law. It contains all the essential elements of a contract to deem it legal and enforceable. Therefore, an enforceable contract must contain all the essential elements of a contract. They are an offer. What is an offer? When there is an offer, it means that there must be a proposal of terms presented by one or more of the parties for the other to accede to. It must be positive, direct, and unambiguous so that the other party or parties to whom it is presented are capable of understanding the terms proposed to them and capable of understanding them. Thus, an offer must be effectively communicated for it to be a valid offer. It must be certain and it must contain certain definite terms. The parties must be clearly stated. The length of time for the performance of such contract must be clearly stated. The price of value must be clearly stated, and also the subject matter of the contract must be clearly stated. Okay, there is something in law that looks like an offer, but it is not an offer. It is not a valid offer, and this is known as invitation to treat. An invitation to treat is not a valid offer. It is a preliminary move in negotiation which may produce a valid offer and thereafter lead to a contract. It is a solicitation for an offer, that is, offer to receive offer. Therefore, an invitation to treat is not a valid offer. So let's move on to the next one. The next one is acceptance. An essential element of a contract is acceptance. Acceptance is where the party or parties to whom an offer has been made agrees or accedes to that offer. It must be unequivocal and unqualified. An acceptance, you must accept an offer on all terms. It must not be conditional or a counter offer. A conditional acceptance and a counter offer is not a valid acceptance. However, there are exceptions to this, and that is why you need a lawyer to understand when a counter offer can actually be valid. Okay, the next one is consideration. Consideration must be mutual. Both parties must give something of value and receive something of value. If only one party receives value from an arrangement, it is a gift and not an enforceable contract. It simply means that what one party is giving in return for what the other party is giving or has agreed to give. Let me take that again. It simply means what one party is giving in return for what the other party is giving or has agreed to give. It could be monetary, it could be a forbearance or an undertaking. So there must be consideration. Consideration could be monetary, cash. You're giving cash, or a forbearance or an undertaking. Something of value must be given and received. Okay, there must be capacity to contract. Only persons who are of contractual age, that is adults, and persons who are mentally capable are legally recognized as being able to enter into a valid contract. The contractual age in Nigeria is actually 21 years. Any person who is below 21 is deemed a minor and unable to enter into a contract, except in certain circumstances. You see, you need a lawyer to know when a minor can actually enter into a valid contract. Okay, so these are just tips. Then the other one is intention to create legal relation. It must be clear from the parties' agreement that they intend to be bound legally by the terms and conditions of such agreement, either immediately or at a certain time in the future, or upon the occurrence of a particular event or contingency. Okay, so these are the essential elements of a valid contract. Okay, they are offer, acceptance, consideration, and intention to enter into legal relations. So when all these are present in a contract, then they are enforceable. This is what makes a contract enforceable. Okay, when a contract is breached, when a party to a contract or parties to a contract go contrary to the terms provided for in the contract, the aggrieved party is entitled to certain remedies, which includes damages, which could be monetary, specific performance where the court orders the party to perform his part of the undertaking of the contract, his part in that contract. The court orders him to do his own part, to perform his obligation. So specific performance, it could be an injunction, it could be rescission, restitution, reformation, among others. It is important to know that there are factors that actually vitiate a contract, that makes them void or voidable. They include mistake, duress, misrepresentation, undue influence, and illegality. These are the factors that can affect the validity and enforceability of a contract once it has been formed. So even if a valid contract is formed and these factors are present in such a contract, such as mistake, duress, misrepresentation, illegality, these can vitiate such valid contract. Okay, so I talked about void and voidable contracts. So a contract, when vitiated, could either be void or voidable. So a void contract is null and void from the time it is created. It becomes invalid at some point in the future, while a voidable contract remains valid until the dissatisfied party cancels the contract at a certain time, or if certain conditions are not met. Okay, in a voidable contract, one party is legally empowered to decide whether or not to perform its part. So a void contract is one that is null and void ab initio. From the time you enter such a contract, it is null and void. It can't be recognized. Nothing can be done about it. No contract is before the court. When you come before the court, there is nothing before the court. However, a voidable contract is one that one of the party can pull out from if dissatisfied. Do you understand? He's empowered to pull out from it if he's dissatisfied. Okay, it is also important to note that what you name a document does not determine whether it is a valid contract. The name you ascribe to a document doesn't determine whether it is a valid or an enforceable contract. What determines it is the presence of the essential elements we have talked about. Okay, let's take, for example, just one example, a memorandum of understanding, MOU. A memorandum of understanding is an agreement between two or more parties outlined in a formal document. It is not legally binding. An MOU is not legally binding, but signals the willingness of the parties to move forward with a contract. It is an intention to enter into a contract. Okay, so an MOU, when you have an MOU, a document is written as an MOU. Some people think it's a legally binding contract. No, it just shows the willingness to enter into a contract. It is a formal document, but it is not a valid contract. It just shows the willingness of the parties to enter into a more legally binding contract. How this is supported by the decision of the court in Oraka and Oraka citation 2019 LPELR 47675CA. However, the court in Staff Finance and Property Limited and another versus Nigerian Deposit Insurance Corporation 2012 LPELR 8394CA. The court, however, held in this particular case that where an MOU fulfills the elements of a contract, then it can be binding, which means that when a memorandum of understanding has all the essential elements of a contract we have talked about, which is offer, acceptance, consideration, capacity to contract, and intention to enter into legal relation, then such an MOU will be deemed a valid contract. So what is essential before you can actually say you entered into a valid contract with someone, before you can actually approach the court for redress, for remedy, for breach of contract, you must ensure that what you entered into with another person is actually valid. And what makes it valid and enforceable are the presence of the essential elements. So in order to avoid errors and mistakes, always brief a lawyer before entering into any contractual arrangement to avoid stories that touch the heart, in Nigerian parlance, as we say. Okay, see you soon, and please, I expect to see you in my next post. Subscribe to this post, as I said before, like and comment. Thank you so much.